Hello and welcome to Win Without Law School. I am Arizona lawyer Julie Labenz. Today, we are going to talk about disclosure in the context of a divorce or legal separation case. First, we will define disclosure, and then we'll talk about the specific disclosure requirements for legal decision-making and parenting time, for child support, spousal maintenance, and legal fees, for property and debts, and then for witnesses and exhibits. So what is disclosure? Well, this is controlled by Rule 49 of the Arizona Rules of Family Law Procedure. And it requires the parties to exchange information so that everybody is, has the same information as they're going through the case. So disclosure is intended to ensure that each party is fairly informed of the facts, data, legal theories, witnesses, documents, and other information that is relevant to the case. A party must disclose information in the party's possession and control, as well as information that the party can determine or acquire by reasonable inquiry and investigation. For good cause, the court can limit disclosure. And you will serve your initial disclosure statement 40 days after the filing of the first responsive pleading to a petition. So we're talking about divorce and legal separation. The petition is filed, the petition is served, and then when the responding party files their response, 40 days after the response is filed, that's when each party is supposed to disclose their initial disclosure statement. And then keep in mind that you have a continuing duty to disclose. So each party is required to serve additional or amended disclosures when new or additional information is discovered or revealed to the party. And you're supposed to do that within 30 days of discovering or, coming into possession of that additional disclosure. If your case has been set for a trial, then you need to disclose anything new as soon as possible. And, really, if your trial's coming up, you've got to get that disclosed as soon as possible if it's something new that you want to use at the trial. Let's look at the required disclosure for legal decision-making and parenting time. So of course, this is going to be in the context of a divorce or legal separation with minor children. If you've got a divorce or a legal separation without minor children, then none of this will apply to your case. So if your case involves kids, then for legal decision-making and parenting time, you must disclose the following documents in your initial disclosure. Number one, a copy of any past or current protective orders and the underlying petitions involving a party or member of the party's household. The name and address of each treatment provider and period of treatment for any party for psychiatric or psychological issues, anger management, substance abuse, or domestic violence within the last 5 years before the petition was filed. And then the date, description, location, and documentation of any criminal charge against or conviction of any party or member of the party's household within 10 years before the filing of the petition. And finally, the date, description, location, and documentation of any Department of Child Safety investigation or proceeding involving any party or member of the party's household occurring within 10 years before the petition's filing. So there's a question, who's included in a household? Well, someone who lives there. So anybody who lives in the house is part of the household. When we look at 1 through 4, you'll see that for 1, 3, and 4, those are going to apply to a party or a member of the party's household, whereas number 2 only applies to the parties. So just little distinction there to keep in mind. Can a caregiver be part of the household? I don't know. Generally, in my mind, and I don't believe that a household is defined under this rule. So there's certainly an argument could be made to expand the definition. But in my mind, member of a household would be somebody who lived under that roof. You could certainly, through discovery, okay, interrogatories, request for production, request for admissions, depositions, gather information about a caregiver. So there's other ways to get information about somebody who spends time in a household but isn't necessarily a member. The other option would be to try to demand disclosure claiming a caregiver qualifies as a member of a party's household, but it may be a more efficient outcome to just make a discovery request about it. So then we had a question, does a grandparent qualify? If the grandparent lived with the parent, so if they lived within that household, they had a room there or a guest house, yes, that would be part of the household. But if the grandparent had their own separate house, then no, that they wouldn't be a member of the party's household. Okay, let's go on. Oh, we've got one more question. Underlying petition, what does this include? Well, we're in the divorce context, so that's going to be your petition for dissolution of marriage or your petition for legal separation. If you're seeking legal separation, that's going to be your underlying petition in the divorce and legal separation context. Okay, now let's look at the required disclosure for child support, spousal maintenance, and legal fees. So this is going to be required, number one, if your divorce case or your legal separation case involves minor children, and in that event, child support would be at issue. If either party is requesting spousal maintenance so look back at the petition, the response, you can see the section on spousal maintenance. If either side is requesting it, then this disclosure is required. And then also if either side is requesting an award of legal fees. So if you are requesting an award of legal fees and costs in the case, you would need to produce this information. If the other side has a lawyer and is asking the court to order that you pay their legal fees and costs, they would need to provide this information, and you would need to provide it as well, because all of that would be an issue in determining whether or not legal fees should be awarded. So we set a question, how do you avoid legal fees? Well, the standard for the court in a divorce context and also in a custody matter is to look at, number one, the financial resources of the parties. And in my experience, that's where the court gives the most attention. And then secondarily, looking at the financial resources of each part, the financial resources and then the reasonableness of each party's positions throughout the case. So if one party has a lot more money than the other, then it's very unlikely that the person with less money would be ordered to pay the other side's legal fees, unless the person with fewer financial resources was just completely unreasonable. But even in that situation, if the financial resources, there was a huge discrepancy between each side, it still may not be ordered. So there's a lot of case law on legal fees. There's a lot more detail to it, but that is the basics, which is financial resources of each party and the reasonableness of positions taken throughout the case. All right, let's look at this required disclosure for child support. So if child support's an issue, you've got to do an AFI. So an affidavit of financial information, you've got to fill that out. And then you need to provide proof of income from all sources, including your tax returns, W-2 forms, 1099s, and K-1s from the last 3 years, and year-end information for the most recent calendar year if tax returns are not yet due. So if, for example, you're in the month of February and you're doing your initial disclosure statement, you may not have filed your taxes yet because taxes aren't due till April. And so if that's the case, then you're supposed to provide 3 completed calendar years of tax returns plus a year-end information statement for the most recent calendar year. Also, information for the current calendar year for all income sources, and there's a broad definition here of what income sources are. So read through that, read through all these different types of income if you have questions in your case about whether or not certain income qualifies. What you're going to start to see here in these next subsections is that all of them are related to parts of the child support calculator. So either side can get a credit in the calculator if they're paying child support or spousal maintenance in a different case, okay, to a party for any case other than the one for which disclosure is being provided. So if you have a child from a different relationship outside of your divorce case, and you're paying child support, you can provide proof of what you're actually paying, and then you can get a credit for that in the child support calculator. There's also a credit in the calculator if you pay insurance for your minor children. So here's a requirement to disclose proof of your payment so you can get credit for it. In the child support calculator, you can get credit for paying childcare expenses for a child at issue in the divorce or legal separation. So provide proof of the childcare expenses you're paying. Now, with medical insurance, you're likely paying a set amount per month. You will need to distinguish between what amount is covering you and what amount is covering your child or children. You can do that by asking the provider to write you a letter about how the coverage works out, or you would prorate it, like if the coverage covers 2 people, divide it by 2, if it covers 3, divide it by 3, and then you get a credit for whatever portion of that applies to the children. For childcare expenses, if you incur the same amount per month throughout the year, then it's easy to determine the monthly amount. But if you incur childcare expenses only certain months of the year, you'll need to prorate that amount into a monthly amount. So when you're providing proof of your childcare expenses, you'll want to provide proof of that type of information. Are you paying a certain amount every month or only certain months? You want to make that clear in your disclosure. In the child support calculator, there's a discretionary credit for paying for schools or special education needs for children. So if you're paying anything like that, you can disclose proof of your payments. And again, if it's not something you pay for all 12 months of the year, indicate that in your disclosure. And then you can get credit in the calculator if you're paying additional expenses for special needs of a gifted or child with disabilities. So if you've got a gifted child or a child with disabilities that's at issue in the divorce, you can disclose proof that you're paying certain special expenses for them. Now, if you're paying those expenses, but then you're also getting money from the state as like a benefit, some sort of welfare benefit, then you don't get credit for it. This is stuff you're paying out of pocket and you're not getting any reimbursement for. So not all of these required disclosures, not all of this is going to apply in every case. You know, if you have a divorce case with teenagers, you likely don't have childcare expenses. Not every, actually in my experience, very few cases involve this extra expenses for private or special schools or particular educational needs. And then, if you do have a special needs child and you're not receiving any reimbursement for those expenses, you can provide proof of those, but maybe you don't have a special needs child. So again, not all of these are going to apply, but you need to identify which ones do apply in your case and disclose the information that you're required to disclose. We have a question about what if one parent wants to go to a private school? Within the Arizona Child Support Guidelines, it indicates that if one parent wants to go, then they can pay for it. And the credit is discretionary within the calculation. But you can't force the other parent to pay for it if they aren't in agreement. Now, that could be different depending on if there's certain language in a parenting plan that's already been agreed to. But in this context we're talking about today, which is divorce and legal separation, where you don't have a parenting plan, you're going to be creating one, that wouldn't be an issue. Do we have to submit the discovery request to court or just to the opposing party? For a discovery request, it just goes to the opposing party. It's not filed with the court. Here we're talking about disclosure, and same thing with disclosure. Disclosures are exchanged between the parties and are not filed with the court. All right, so if child support is at issue in your case, you're going to need to do an affidavit of financial information, provide your last 3 years of tax returns, your proof of income, year to date, and then any of these potential credits you may qualify for in the calculator, you want to disclose information about those. All right, let's look at required disclosure if your case involves spousal maintenance and if either party is requesting legal fees. For spousal maintenance and attorney's fees and costs, if either party has requested an award of spousal maintenance or an award of attorney's fees and costs, the following documents must be served with the initial disclosure: a completed affidavit of financial information and the documents and information described in subpart E2, which is what we just went over for child support. So here's E2, which is proof of income, your tax returns, proof of income. Now, this other stuff related to really child support, that's probably not going to be something to produce, because you'll see a lot of this is related to children for spousal maintenance. So it likely should say, produce what's required under E2A and B, maybe even C, but these likely aren't going to apply as far as spousal maintenance. As far as legal fees go, these show more of the expenses you have. Also for spousal maintenance, if you're paying any of these expenses for a child, of course, you could have that be factored in to a spousal maintenance claim. So these could be relevant, or you may be looking at them and being like, how does this apply? It doesn't apply in my case. That's fine. Especially if you have a case without children, these things aren't going to come up. So again, look at this rule, see what's required, and see what actually applies in your case. Okay, now we're going to get into the required disclosure for property and debts. So we've covered what's required for legal decision-making, parenting time, child support, spousal maintenance, and attorney's fees. And now let's look at for property and debts. Okay, first of all, there's going to be a requirement to disclose documents related to real estate. So if you or your spouse own real estate together or separately, you're supposed to disclose deeds, mortgages, purchase agreements, settlement sheets, basically any documents that show the ownership of the property, the legal description, the purchase price, and if there's any encumbrances, any loans, mortgages, things like that recorded against the property. And then just to make this point clear, you may be thinking you only have a duty to disclose marital property, but that's not what this says. It's disclosing documents related to real estate owned by any party. So there's not a distinction between community property and separate property. The Rule 49 is wanting you to disclose any interest any party has in real estate, whether it's separate or community. All right, number 2, you need to disclose bank statements starting from 6 months prior to when the petition was filed through the date of your disclosure. So if the petition was filed on December 31st, you'd go back 6 months. Okay, so you need to provide bank statements for June, July, August, September, October, November, December. Actually, you could probably start in July. That would take you to 6. And then let's say you're doing your disclosure in February. So you'd go July through January or February, depending on whether or not the February statement had come out yet. So it's a lot of documents. It's a lot of paperwork. You could have 2 or 3 bank accounts, and, with every bank account statement, there's a couple ads and additional blank pages. I mean, it's a lot of papers. So what you're going to start finding is that you're going to need to make a decision. Am I organizing this all by hard copies? Or am I organizing this all by electronic documents? And if you're doing electronic documents, then you need to start organizing all of this, on your computer in folders and, by these categories. So everything's very clear. And then you can also, once you have it all set and labeled and organized, you can burn it to a disk or transfer it to a USB and then provide that to the other party instead of the big stack of paperwork. Now, technically, under the rules, you're supposed to provide the other side with the big stack of paperwork, but not everybody wants that. So that's where you can communicate with the other side, provide them the electronic copy, and then ask, are you requesting a hard copy of this? If so, I'll comply with the rule. But, it's sometimes hundreds of pages. So as you're gathering these documents, if you're going the hard copy route, then start making your copies. On the flip side, if you're going the e-copy route, then start organizing your documents in a very systematic way based on, okay, here's a folder for legal decision-making and parenting time disclosure. Here's another folder for child support. Here's a folder for property. And then within that, here's a subfolder for real property. Here's a subfolder for bank accounts. Getting really intentional with how you're organizing everything. Okay. There's a question about, do you need to disclose joint vehicles? So let's get to the part about vehicles and let's look at the rule in the context of your question. Okay, but first we've got number 3 here, which is that in addition to 6 months of your bank statements, and it's actually going to be a bit more than that. It's probably going to be around 7 or 8 months of statements by the time you do your disclosure. You also need to provide copies of retirement account statements. So pension, 401ks, IRAs, any type of retirement account that you have an interest in, you need to disclose documents related to those accounts. Sometimes those accounts aren't monthly. Sometimes, they're by quarter. So you'll disclose whatever type of statements they have, just so long as they extend back for 6 months through the date of the disclosure. So again, these documents can be really long too. Sometimes they're 20+ pages per statement. So you got to decide, are you doing hard copies or are you doing e-copies? Next, we've got life insurance policies. If any party to the divorce has an interest in a life insurance policy for 6 months prior to the petition's filing through the date of disclosure, then they need to provide all monthly and periodic statements and documents showing the cash surrender value, face value, and premiums charged. All right, now we're getting into real or personal property. And you're required to disclose information that may assist in identifying or valuing any item of real or personal property in which any party has or had an interest for 6 months before the petition's filing. So I think, Roxanne, your question was about being a co-signer on a debt. I'm not sure I don't know if you were on the title. If you were on the title to the vehicle, then you would have an interest in it. And if you were on the title to the vehicle 6 months prior to the petition being filed, then you would be required to disclose information about that car. So if you are on the title, then that's technically deemed an interest in the vehicle, even if the interest in the end turns out to be 0 because of the math involved. If you're on the title, then you are required to disclose information about it. So, okay. Now we've got number 6. If a business was started during the marriage, or if either party had a business prior to marriage or has some interest in a business, then you need to disclose all this information. So read through this, and it's extensive. It's for the past 5 calendar years or fiscal years. So there's a lot to disclose when there's a business involved. If either party has a beneficial interest in a trust, so a trust is an estate planning tool, And so if you created a trust during your marriage, or if your parents have a trust and you have a beneficial interest in it, you're supposed to disclose a copy of all documents related to any trust you have a beneficial interest in. And then a list of all items of personal property, including but not limited to furniture, furnishings, antiques, artwork, vehicles. So Roxanne, here's the vehicles, jewelry, and similar items in which any party has an interest, together with the party's estimate of the current fair market value, not replacement value, for each item. Okay, now this can be a bit overwhelming. What we're looking at is during your marriage, you and your spouse acquired a bunch of stuff that doesn't have a title associated with it. So, your couch, your beds, all the stuff in the kitchen, everything that furnished your house is under this category of personal property. And then jewelry, artwork, those things also come into play. And then vehicles. Now, vehicles do have titles, but vehicles are also part of your personal property. So what this is asking you to do is start creating a list of all the marital personal property, everything in the house, essentially. Now, it's up to you how detailed you want to get with this. Some people itemize get down to every fork and spoon. Other people go for just the big items. Okay, I go in this room, there's a bed, there's a dresser, the big stuff. But the bottom line is what you're looking at is, how is this going to be divided up? If you and your spouse are communicating, maybe you can just get together one day and figure it out and call it good. But if you're not, then you need to declare what your position is. What are all the items? What do you think they're worth today? And it's going to be the current fair market value. So a lot of people are like, oh, well, I paid $500 for that 5 years ago. And it's like, okay, but it's used now. And that was 5 years ago. So what is it worth now? So it's the value of the used property as is, not what it would cost to replace it or what you paid for it. It's going to be, what is its current fair market value? Some things you need to do some research. You can go on Craigslist, you could go on eBay, you can go on Facebook Marketplace and look for the particular item, see what it's being listed for sale for, and start getting some reasonable values if you're struggling with that. When you create your list, if you want to be really on top of things, then I would encourage you to indicate what items you want and what items you want your spouse to have. Because that's really the next question, is who's getting what, and are you guys in agreement or not? So you can create the list, but while you're creating the list, you can also, organize it so that one side showing all the things you want to be awarded and their value, and the other side is what you want to go the other side in your estimated value. And then you can add up each side's column and see what the total value is and see if it's equal or not, and if there may need to be some sort of equalizer payment. So there's a question about, how do you determine the value of a vehicle? And yes, you'll need to go to Kelley Blue Book or Edmunds and do some research. Vehicle values are often something that's, disputed, but you got to really be practical with it. I like to look at, okay, how much are they saying the car's worth? How much are we saying it's worth? Can we meet in the middle? Sometimes it's, a $500 difference. Sometimes it's $1,000 difference. Can we just meet in the middle and move on? But yes, you will need to declare what you believe each vehicle is currently worth. And of course, if the vehicle is subject to a loan, incorporate that in. What's the current value of the loan, and subtract that from the value of the vehicle to get a net value. And that's what you're going to work with. When you create your list of personal property, I encourage you to use an Excel spreadsheet. That helps you just organize everything, tally up your values really easily. You can move things around really easily. So I'd encourage you to use an Excel spreadsheet for that if you can. Now let's look at required disclosure for debts. So we looked at property, and now let's look at debts. The first is going to be disclosing statements related to mortgages, notes, liens, and encumbrances against real and personal property. And the amount of time is expanded for debts. You saw on the property section, it was generally the 6-month time frame. Now we're working with 11 months. So this is, again, a lot of paper, 11 months worth of mortgage statements, for example. So I definitely encourage people to go the electronic route, even though the rule requires us to disclose hard copies. Nobody really wants this much paper, and it's so much easier to work with and organize these documents when they're in electronic format. In addition to mortgage statements and things like that, you also need to disclose credit card statements for the last 11 months through the date of disclosure. So any credit cards that are joint credit cards between you and your spouse, or credit cards in your name, you need to disclose all these statements for 11 plus months. All right, let's do a summary of the required disclosure for property and debts, because I know it was a lot. And this is where, the majority of your disclosure is likely going to be in a divorce or legal separation case. So first of all, we've got real property, disclosing all documents showing ownership, legal description, purchase price, and encumbrances. Accounts, bank accounts, investment accounts, brokerage accounts, disclosing those statements for the last 6 months through the date of disclosure. Retirement accounts, all statements from all retirement accounts for the last 6 months through the date of disclosure. Life insurance, disclose the statements and proof of cash surrender value. There were 2 other parts, the premiums being paid and the overall value. You can look back at that rule for 6 months prior to filing through the date of disclosure. And then any documents that assist in determining the value of real or personal property. Let's say you had an appraisal done, disclose that. Business, tax returns, profit and loss statements for the past 5 years. A trust, a copy of the trust that you or anybody else, you or your spouse has a beneficial interest in. Personal property, create and disclose a list of personal property and vehicles, along with your estimated current value. Disclose statements for debts against real or personal property for the last 11 months up through the date of disclosure. And then same thing for credit cards, 11 months up through the date of disclosure for credit card statements. There was a question about the requirement to disclose the trust. It's a trust you have a beneficial interest in. If you already received your inheritance and the trust is closed up, then that's not what's being asked. It would be an existing trust that you're named as a beneficiary under. Okay, and then remember, you have a continuing duty to disclose. So the duty of disclosure is a continuing duty, and each party must serve additional or amended disclosures when new or additional information is discovered by or revealed to the party. And you're supposed to do that within 30 days. So you'll spend all this time getting your initial disclosure together, and then technically you're supposed to continue sending out your monthly statements and things like that. It's not something that is kept up very diligently in most cases, but I bring it up in the event you get a demand from an opposing attorney. Hey, you need to give me more bank statements or more credit card statements. You'll see that, oh, okay, that is required under my continuing duty. Or if you're wanting to get that from the other side for some reason, here's your basis for making that request, that there is this continuing duty to disclose. All right, let's look at required disclosure for witnesses and exhibits. Anybody you want to testify, you need to disclose their contact information and a statement fairly describing the substance of their expected testimony. There's even more required disclosure for an expert witness. You need to disclose their contact information, the subject matter they're going to testify about, the substance of the facts and opinions on which they will testify, a summary of the grounds for each opinion, their qualifications, and the name and address of any custodian of reports the expert prepared. Now, out of everything that we just went through, let's say you have other documents you want to use in your case. For example, text messages between you and your spouse, or your child's attendance record at school, or something like that, something that's beyond what was listed in the required disclosure. You can and should disclose those additional exhibits. And so if you have documents, audio recordings, or videos not listed in your disclosure that you want to use at a hearing and or trial in your case, then you must disclose each document, audio recording, and video you intend to use in your initial disclosure or in a supplemental disclosure statement. Is this listed in Rule 49? The part about the trust, I'm not sure what you're asking about. If that's what you're asking about, yes, but you'll need to clarify that question. Okay, so I encourage you to create a master list of your exhibits, keep them in the same order once the list is created, and then add to that list via supplemental disclosures. There's a question, who do we hire to find out an interest in a business? That would be a business appraiser. And so it costs $5,000 or more to get a business appraisal done. They'll look at 3 to 5 years of business records, and then we'll issue a report about the value of the business. You can, in a divorce, ask that cost be shared. You can ask the other side pay for it. So there's ways to either not pay it and still get it done, or divide up the cost. Disclosure statements are not filed with the court. They're just exchanged between the parties. So you create your disclosure statement and you serve it on the other party by sending it to them by mail, emailing it to them if they're in agreement to receive it by email, or hand delivering it. Yes, the numbers that what I'm referencing in these slides here, like this subsection L, these are from Rule 49. Yes. Okay, so disclosure just goes between the parties. It's not filed with the court. Okay, now let's look at Maricopa County's standard form for the initial disclosure statement. And what you're going to see is that all of these headings are what we just covered. So obviously fill out your caption, your case number, indicate which party you are. And then here, legal decision making. What this document is saying is take this document, there's 11 pages, and at the end of the 11th page, attach a document that says Exhibit A. And then behind Exhibit A, have any protective orders, any treatment provider, have the information about them, any criminal charge or conviction information, and any information about a DCS investigation or proceeding. So here, you could have A1, if you have stuff on that, A2, A3, A4, you could create dividers to keep it all very organized, like just a piece of paper. It could be a different color. It could just be labeled Exhibit A1, A2, things like that. And then if you have a divorce case and there's no kids involved, then you're not going to have anything for Exhibit A. So you don't need to do anything for that. Child support, Exhibit B. So after your Exhibit A, you can put a document that says Exhibit B. You'll attach your AFI, and then any evidence that you have related to 2 through 7. Again, not all of these will apply in every case. So see what applies in your case and then provide that documentation. So, that can be B1 is your AFI, B2 are, your income tax information, your tax information and income information. B3, B4, you can organize things really nicely. either in hard copies or electronically. C, spousal maintenance, attorney's fees and costs. Now, a lot of this, if you did the child support section, you will have already done that. So you could do Exhibit C, see Exhibit B. On the other hand, if your case doesn't involve child support, but it does involve spousal maintenance and or attorney's fees, then you can do an Exhibit C and enclose this information. Next, we get into property, Exhibit D. So D1 is going to be the real estate documents. D2 is the bank account documents, the bank statements. D3 are the retirement account statements. D4, life insurance policy statements. D5, anything that's going to help in identifying or valuing an item of real or personal property. D6, business documents. D7, your list of personal property and vehicles and their values. And then Exhibit E, debts. E1 is your monthly statements related to mortgages and things like that. E2 are your monthly statements for credit cards. Exhibit F is going to be your witnesses. Exhibit G are expert witnesses if you have them. And then this is just reminding you of your continuing duty to disclose. But, we talked about, well, what if you have additional exhibits? That's where you can create an Exhibit H. And then, or you could have Exhibit I if you want to do it down here. You could even write it down here because there's more room. And list, Exhibit I, list of additional exhibits. And then list them out. You can even say see attached, have a page in the back, list them out, and then have that be Exhibit H or Exhibit I and go accordingly. If you do Exhibit H, then I would change this to I. I'd cross it out and make it an I. If you leave this in and you do I down here and either utilize this space down here or attach additional page and then create Exhibit I and attach your additional exhibits. Here's their form for Exhibit F. So you can use this form for the witness information. They give you space for 4 witnesses, 5, 6 witnesses, and then expert witnesses. They give you a bunch of space for those. Here's your mailing certificate page. So fill that out when you're ready. And then for your additional exhibits, this is just what we talked about, create the additional exhibit, list them and add them. And then I've talked about this a little bit already, but just to really drive this home, if you're producing hard copies, organize all the documents by exhibit, ideally put a colored piece of paper between the different documents, and then mail or deliver the hard copies of your initial disclosure statement and supporting exhibits to the opposing party or their attorney. If you're doing e-copies, confirm the opposing party or their attorney agrees to accept your disclosure in the form of e-copies. And then if they agree, then organize all of your documents by exhibit into a master PDF and have everything labeled and really get into organizing it. Then you can mail or deliver a hard copy of your initial disclosure statement. So just the Maricopa County standard form that you filled out, but then have all the exhibits that support it, burn those to a CD or save them to a USB, and then give that to the opposing party, either by mail or hand delivery, possibly even by email if they're in agreement with that. Okay, we've got a question. E-file. No, disclosure statements are not filed with the court, so you would not e-file. No, that would not be e-filed. You would go either through mail, direct email to the other side if they're in agreement with that. But, if you've got a huge amount of documents and you've burned them to a disk, you can't email the disk, or if you've saved them to a USB, you can't email that. So that's where I'm saying it's most likely going to be by mail or hand delivery. All right. Proposed resolution statement. This is required to be disclosed 30 days after exchanging your initial disclosure. But keep in mind that most often You will file your proposed resolution statement 3 to 5 business days prior to your resolution management conference and mail a copy to the opposing party or their lawyer. So what the court generally does is the petition for divorce gets filed, it gets served, the responding party files their response, and then approximately 40 days after the response is filed, the court is setting the resolution management conference on or around that 40th day. And according to the rules, your resolution management statement is due 3 business days prior to your resolution management conference. However, in some counties, it's 5 days, like in Yavapai County, it's 5 business days. So you file that statement 3 to 5 business days, depending on what your order says, and provide a copy to the other side. So here's the form. Is there a quick picture of the timeline of this? I mean, this is I would say, look at how this whole program has unfolded, because if you go back through each of the classes, that whole procedure is in there. Create your case strategy, initiate your case, serve it. The other side gets to respond. Then now we're talking about disclosure and the proposed resolution statement and the RMC. So, we're going through the procedure through the classes, and it's all outlined there in how the classes are organized. Okay, so we're talking about required disclosure, and we saw under Rule 49, it stated that a proposed resolution statement is part of your required disclosure. It's just not due necessarily at the same time as your initial disclosure. However, it could be if the court so ordered. So you'll fill out the caption here and start filling this out, and keep in mind that this form is where you're putting in how you're proposing to resolve your divorce. And you may or may not at this stage in your case be ready to take a position. So if you don't know yet on certain things, you can indicate that in here, still getting information, not ready to take a position yet. You can do that. On the other hand, if you know exactly what you want and you know what you would settle the case on today, that's what should go in here. Because at the end of this document, you'll see there's a paragraph that says that you are swearing and affirming that you would settle the case on these particular positions you're putting in the document. So this is to help the parties see what are they in agreement on, what are they disputing, to help the court then narrow the issues down and move the case forward more efficiently. So that's why it's called a resolution management conference, because the court is managing resolving the case. So in order to do that, the court wants to see how does each side want to resolve the case. And so that's what this form is about. So fill out what you want for legal decision-making, parenting time, child support, again, if you know, spousal maintenance, any property you want declared your separate property, any community liens on separate property, and then get into all this information about community property. See all the different categories. The tangible personal property, indicate what you want to happen, get into the debts, attorney's fees, restoration of last name, if that's at issue, any other issues. And then here is that statement. I understand, first of all, you're required to meet and confer with the other side at least 5 days, court days before the court date. And then you verify that the above statements are true based on your best information and belief, and that you're willing to settle and resolve your case based on your positions in this document. Okay, so then you'd sign this. Here's the mailing certificate, fill that out. This does get filed with the court, and then a copy gets mailed to the other side. Affidavit of financial information. So this is another required form for child support, spousal maintenance, or if either side requests attorney's fees. You'll remember this rule that requires the affidavit of financial information and all this other documentation about income and expenses. So here's the AFI form. And you really want to fill this out as accurately as possible. Now up here, it talks about documents you can attach, but if you're going to attach, for example, tax returns for the last 3 years, this document gets really long. Plus this document gets filed with the court, and the court really doesn't want you to file your last 3 tax returns with the court. And you don't really want those filed with the court because what you file with the court is a public record. So for my clients, I'll generally put no here, but I'll indicate that I disclose this in my initial disclosure. So it's not attached here, but I did disclose it. So fill out your information here. Information about your employment, education, income. And then if you own a business, this is information about your business. Any special expenses for your children. And then if either side is requesting spousal maintenance, division of expenses, attorney's fees and costs, adjustment or deviation from the child support amount, or you wouldn't be in enforcement at this stage, but any of those, then you also need to do section 7 and 8, which are your current monthly expenses and debts. And then here's the signature page or the mailing certificate page. Just for the AFI, I encourage you to be as accurate as possible. Some people are like, oh, I'm going to make my finances look like they're better than they really are, so the judge thinks I'm good at managing money. But that doesn't necessarily help your case. So it's usually best, and this is a sworn document. You're swearing and affirming this information's true, so it needs to be accurate. Also, keep in mind that you may need to research through your bank statements and your credit card statements and things like that to get the accurate numbers for this document. Most people don't have all of these numbers just off the top of their head. So keep in mind, you will need to do some research to get accurate numbers. All right, we have reached the end of today's presentation. So let's go through a summary of what we covered today. So first of all, disclosure is due 40 days after the filing of the response to the petition for divorce or legal separation. And then both sides have the ongoing continuing duty to disclose, and you're supposed to do that within 30 days of obtaining the information or discovering it. And then just keep in mind that there's specific disclosure requirements for legal decision-making and parenting time, child support, spousal maintenance and legal fees, property and debts, witnesses and exhibits. And then there's also the requirement of the proposed resolution statement. Ongoing for how long? Well, as long as the case is open, you have the duty of continuing disclosure. So once the case is set for trial, there's a final disclosure deadline. So that's when that would be your final disclosure. But otherwise, up until that point, you have an ongoing duty to disclose. All right, and then there's these 4 things that are required for legal decision-making and parenting time. Not all 4 of these are going to apply in every case, so see what does apply, but it's related to protective orders, treatment, criminal charges or convictions, and DCS investigations or proceedings. And then for child support, spousal maintenance and legal fees, you've got the AFI, and then proof of income, and then proof of any credits you're wanting to get within the child support calculator. And then for property and debts, you've got real property, your bank accounts, your retirement accounts, life insurance, anything that shows values, business documents, a trust, the list of personal property and your estimated value, and then the debt statements and credit card statements. So a lot of required disclosure in a divorce case. And then, of course, remember your continuing duty to disclose. So you don't just get to do the initial disclosure and that's it. You need to continue to disclose. You got to disclose all your witnesses, their contact information, and the substance of their testimony. There's a lot more stuff that needs to be disclosed for expert witnesses. If you fail to disclose a witness in a timely manner, you may not be able to use the witness at the hearing. And then anything outside, beyond all the stuff you need to disclose per Rule 49, anything else you want to use, let's say there's text messages you want to use, you need to disclose those as well and start creating a list of your exhibits. If you're producing hard copies, organize all your documents really well. You can put colored pieces of paper between the different documents to help organize them, and then mail or deliver the hard copies of your initial disclosure statement and supporting exhibits to the opposing party or their attorney. If you're going the e-copy route, confirm the other side agrees to that, and then organize everything by exhibit into a master PDF, and then mail or deliver a hard copy of the initial disclosure statement with your supporting exhibits on a CD or USB, and mail that or deliver it to the opposing party or their attorney. Then you've got your resolution statement. That's going to be due 30 days after you've exchanged your disclosure or is otherwise ordered by the court. It's usually done, it's usually filed 3 to 5 business days prior to your resolution management conference. All right. That brings us to the end of today's recording. Thank you so much. If you have any questions, please bring those to the Q&A.